I think that is an important lesson as we look at data privacy and AI going forward, because even though there is no federal data privacy law right now, and even though there are, no major regulations about AI, where there's a perceived violation or perceived right, customers, plaintiffs, the plaintiffs bar will find a way, I believe, from my perspective, to assert those rights through existing law until that law is there. And what's interesting about website accessibility in particular is, to date, we still have no national legislation about this issue, or even on a state level about this issue. Yet last year alone, there were almost 3,000 lawsuits. And lawsuits are different from the amount of demands and claims that are made to companies. A lot of them get resolved in confidential settlements. So I would say by the time you're looking at lawsuits, you're probably looking at 10% or 5 to 10% of the amount of claims and demands that went out there by the plaintiffs bar. And this started as an issue where there was maybe a couple of hundred lawsuits in 2017, 2018, and now it's several thousand. And these are legal claims that are brought on the basis of guidelines issued by the World Wide Web Consortium, which is an independent nonprofit organization, and came together to write this very detailed set of guidelines that really have guided the legal landscape in the absence of any clear law on the subject for the past almost a decade now, or they started writing them before, but the legal litigation kind of spun out of control in the past maybe 8 years. So it's from a legal perspective, it's really interesting to see how those guidelines have been used to set the standard, and how courts have followed those guidelines in enforcing and determining whether someone's rights were violated. And the data privacy link is that a lot of times when demand letters would be issued, they would loop in data privacy claims. In other words, not only was a website not accessible because of its kind of physical features, font size, not including closed captioning, contrast levels, things to make it easier for people who had vision issues or were hearing impaired. But now the theory is that you're also violating their data privacy rights, because they are not able to access what their privacy rights are and how their data is being used, because what preceded that was all these terms and conditions disclosures, and companies were putting on their websites, these are your rights, this is how we use your data. But people who were unable to easily access websites suddenly didn't have access to their data privacy rights. So it was a dual violation. And I think working in the luxury industry, there was, depending on the brand, so every brand differed a lot, but sometimes there was a lot of resistance to changing the website because there was concern about aesthetics. But to me, it's an issue of creativity. People in fashion and luxury are very creative, and a lot of the brands, rose to the task of finding creative ways to work this into their websites and the new information and new content that was constantly being added to their website.